Be ready. Start. It may be mentioned that the writ petition was admitted for hearing before a division bench on 9/11/1962. Stop. In this application, reference has also been made to the amending Act number 17 of 1960, whereby the words "for use in the manufacture of goods for sale" were omitted from the definition of the words purchase, an amendment which, according to the averments in this application, was not known to the petitioner at the time of filing the writ petition initially. Stop. Additional grounds were thus sought to be raised, urging the East Punjab General Sales Tax Act number 46 of 1948 to be void ab initio, being an incompetent piece of legislation in view of the bench decision just mentioned. Stop. The provisions of the Punjab General Sales Tax Act of 1948, according to the plea in the application for amendment, can have no legal force until reenacted by competent legislature, and neither the legislature of the East Punjab nor its successor, the state legislature of the Punjab, having reenacted the invalid piece of legislation the amending acts subsequently passed, are inoperative and of no consequence. Stop. This application for seeking permission repeats all the legal arguments in support of the contention that the East Punjab General Sales Tax Act is a void piece of legislation and therefore an absolute nullity. Stop. Notices of this application was also given by a division bench of this court on 7/12/1962, and it was ordered to come up along with civil writ number 1741 on 1962. Stop. At the time of arguments on behalf of the petitioner, the case as laid in the application for amendment has been pressed, and to begin with, Shri Sibal has urged that the impugned tax is virtually and in substance an excise duty which is beyond the competence of the Punjab state legislature. Stop. Reliance has been placed for this submission on various decisions of the Federal Court, the Privy Council and the Supreme Court. Stanza. We have been taken through the entire judgment, and it has been sought to be deduced therefrom that whenever a tax has been imposed on a person qua a manufacturer, then the tax must be considered to be an excise duty. Stop. The council has next taken us through the entire judgment of the Federal Court. Stop. From this judgment also an attempt has been made to support the proposition enunciated by the council that the goods taxed have been subjected to tax qua manufacturer, and therefore the tax must be described to be an excise duty. Full stop. Over.